Morning, students. We are looking into the subject industrial management and entrepreneurship for final year diploma students. I am Sridevi here, head of electrical and electronics engineering section, Department of Technical Education, Telangana. Right. Um, Before going into today's session, we'll just have a quick recap of what we have seen in the last class. Right. We have seen the various causes of accidents. We are looking into the unit personal management, second unit personal management. In that, we have seen what are the various causes of accidents, safety precautions to be followed, Indian Factory Act, ESI Act. We have seen what are the objectives of Indian Factory Act and ESI Act, right? So, in today's class, we shall look into the salient features of Indian Factory Act, a continuation from what we have studied in the last class. We'll look into the salient features of Indian Factory Act, ESI Act. We'll also look into two more acts, Workman Compensation Act and Industrial Dispute Act. Right? So in the last class, we have just seen what is an Indian Factory Act. We have seen that the Factory Act 1948, as per the Act number 63 of 48, it's amended by the Factories Act 1987, serves to assist in formulating national policies in India with respect to occupational safety and health in factories and docks in India. We have also seen that it deals with various problems concerning safety, health, efficiency, and well-being of the employees at the workplace. Right? So, when we have seen this, what seen is in this Factory Act, in order to keep the employees' health, safety, and efficiency at good place at workplace. What we have seen is the basic features. What we have seen yesterday is um, that minimum fencing should be there for the machinery. No young personnel should be allowed to work. Right, no young person below the age of 18 should be allowed to work. We have seen that suitable devices and tools must be available for the work. Suitable gadgets, necessary gadgets must be available for the employees. And if at all there is, if at all the employees are working with a hazardous material like chemicals or radiation material, then uh, protective gear must be provided for the employees, right? And also there must be right, uh, they must be named like danger, it is danger zone, must not enter, or like this. There must have a note on the material. We have seen generally accident when causing due to lifting of material, heavy material and all. um, Provision must be there for lifts, provision must be there for trolleys and all, right? All the floors, steps, all have must be kept clean and without greasy. And no person, only skillful person must be allowed to work on the machinery. This and necessary fire extinguishers or necessary exit gates must be provided. These are all we have seen few of the aspects in Indian Factory Act in the last class, right? Um, we have seen that this Indian Factory Act 1948, it has been enacted to consolidate and amend the law regulating the workers working in the factories. It extends to whole of India and applies to every factory where more than 20 employees, more than 20 workers are there. Right? Since the aim and objective of this act is to safeguard the interest of workers and to protect them from exploitation, the act prescribes certain standards with regard to safety, welfare, working hours of workers apart from other provisions. That's what just now we have discussed. As far as safety is concerned, measures must be there for machinery, For every transformer, there must be measures. We have seen fire extinguishers, proper exit gates, these all must be there. And for the welfare and the working hours, we have seen that the number of working hours must be limited to 48 per week, and one holiday must be given there in a week, and the number of working hours is also have to be fixed, because um, in the last class we have seen the worker or the employee gets fatigue, right? If he continuously works for hour, he may get fatigue, he may fall down, or his efficiency will surely go down, and hence the number of working hours are also fixed, right? Right. We'll just have a quick look at the Indian Factory Act. What is its applicability? What are its welfare measures? What does it ensure the workers of, and all? Just having a quick look at these things. The applicability of this Act, Indian Factory Act: any premises wherein 10 or more percent with the aid of power, right? Or without the, and 20 workers without the aid of power, working in any day preceding to 12 months wherein manufacturing process is being carried on. So for this Factory Act is applicable, right? It is applicable, it is there for the employees pertaining to the health, right? Cleanliness, disposal of waste, and effluents, ventilation, and temperature must be well maintained. Dusting must be done very often, right? Overcrowding must not be there, right? Proper lighting must be there. Drinking water facility must be there, because a person might get dehydrated because of work. So drinking facilities must be there. And for this employee Indian Factory Act, every factory must have registration, right? So registration must be granted by the Chief Inspector of Factories on submission of prescribed form, fee, and also, right, and also the plan of the factory. Because as I've told you, proper ventilation, proper lighting, everything must be there, and so they have to submit the plan also. So if, only when the factories get registered under this, the employees will get these benefits, right? The safety measures which the factories must look into us, so just now told you, fencing of machinery, um, work on near machinery in motion, employment prohibition of young persons on dangerous machine, gears and devices must be provided for switching on the power, switching on and off of the power, right? Proper tools must be used, proper gadgets must be used, and prohibition of employment to women and children uh, in certain industries, right? This must be taken care of. What are the welfare measures under this Act is? Washing facilities, facilities for storing and drying clothes, facilities for sitting, first aid kit, canteens, shelters and restrooms, and lunch rooms for the employees. Crutches must be provided when there are 30 or more women employees, because that is a provision for keeping the small kids, right? To take care of the small kids, they must be provided with crutches when there are more than 30 women employees. Welfare office when there are more than 500 workers must be there, right? Working hours, as I just now told you, weekly hours must not be more than 48, daily hours not more than 9 hours, because employees get fatigue. Intervals of rest at least half an hour on working for every 5 hours, right? And overlapping of shifts must be prohibited. Extra wages for overtime, double than normal rate of wages must be given. Restriction of employment of women before 6 a.m. and beyond 7 p.m. must be implemented. Right? Right. Prohibition of employment of young children. Of course, as we have discussed, only adult workers and fit and the employees who are fit only have to be allowed to work in a company. Right. The workers having worked for 240 days, 1 day in every 20 days leave must be given. And for a child, 1 day working of every 15 days, accumulation of leave for 30 days. So these are all provided, these are all made mandatory as per Indian Factory Act, which looks into the safety, security, and the welfare of the employees working in a factory. Right. So this is the total checklist. Right. Now, what is an ESI Act? ESI Act is Employee State Insurance Act. It is a self-financing social security and health insurance scheme for Indian workers. Right? The fund in this ESI is managed by Employee State Insurance Corporation (ESIC) according to the rules and regulations stipulated in the ESI Act 1948. ESIC is a statutory body and administrative Ministry of Labour and Employment, Government of India. Right? So, under this act, as I've told you, the fund is contributed by the employees, by the employer, right? The total fund, and it is maintained by ESIC, Employees Corporation, right? Employees' contribution will be 1.75% of gross salary. Employers will be 4.75% of the gross salary. The total contribution is 6.5% of the gross salary of each employee or of each worker is being contributed towards ESI every month. Right? So this fund is totally collected and maintained by ESIC. And that is used for the welfare, the security schemes of the various, of all the employees who are being registered under ESI. Right? So I've told you, this is for the benefit, all this fund goes for the providing medical benefit to the employees, sickness benefit, maternity benefit, disablement benefit, dependence benefit, funeral expenditure, rehabilitation allowance. Right? So if at all any employee has undergone any surgeries, right? Then he will be benefited. If at all he met with an accident, then also he will be benefited using this. Right? Women employees will be given maternity benefit. And if at all there is any disability occurring because of work over there, in any industry or a factory, then also they'll be benefited. Right? Dependents benefit. So the children of the employee will be given some provisions. If at all someone passes away, the dependents or the employee, then funeral expenditure also will be supported by ESIC. Rehabilitation allowance, if they are moving from one place to another place, then rehabilitation allowance will also be provided under this act. Right. The ESI scheme provides full range of medical care to all the insured person and their family through a network of ESI dispensaries, hospitals, panel clinics, diagnosis center, and super specialty. Right? The super specialty treatments such as open heart surgery, neurosurgery, bone marrow transplantation, kidney transplantation, or specialized investigations like CAT scan, MRI, angiography, these are all covered in this ESI Act. So, all these things will be supported by ESIC for any employee who is insured under this ESI Act. Right? Eligibility of medical benefit is for any employee who is covered under the scheme for the first time is eligible for medical care for a period of 3 months. So as he keeps on renewing, as he keeps on contributing his fund monthly every month, his tenure for the benefit keeps on increasing. If an employee contributes at least for 78 days in a contribution period, the eligibility is there up to the end of the corresponding benefit period. Right? So there are many benefits of this ESI Act for the employees. Right? For medical expenditures, for maternity leaves, for surgeries, for even sick, when if at all a person falls sick also, these people will support. These even support for, we have seen rehabilitation, for funeral expenditure and, right. There are number of ESI hospitals, ESI dispensaries hospitals across India. In almost every state in India, we have hospitals where the people insured under this act will be treated free. Right. The next comes Workman Compensation Act. Right. This Workman Compensation Act, the objective of this is it aims to provide the workmen and or their dependents some relief in case of accidents arising out of or in course of employment and causing either death or disablement of workmen. Right? This act, Workmen Compensation Act, now it is called as Employees Compensation Act. Right? Now we call it as Employees Compensation Act, but before 2010, it was known as Workmen Compensation Act. Right? So it always helps or supports the workmen or their dependents, provides some relief for the workmen or their dependents in case of accidents occurring due to the machinery or due to anything in the industry or during the course of their employment. It supports that. Right? The scope of this Workmen Compensation Act is, it is a social security law for employees and workers and laborers. The act implies to the whole of India. Anyone working in India, for these all the people, there's workmen who are working. Workmen Compensation Act is applicable. Applicable to factories, mines, oil fields, construction establishments, and other establishments listed in Schedule 2 and 3 of the Act. Of course, it is not applicable for armed forces because they have separate rules and regulations. Right? Armed force is totally a separate entity. They have their own rules, and so that doesn't come under this Workmen Compensation Act. Employees have to provide compensation to the employees. All the employers should provide compensation to the employees for the industrial injury which results in disablement. Partial, it might be the disablement may be partial or permanent due to the accidents or in case of death in the course of employment. So whenever the employee faces with any accident or any disablement or fortunately death occurs in the course of employment, the employers have to provide compensation for them. Of course, the amount of compensation will be given for injuries in course of employment were subjected to nature of injury and percentage of disablement. So how much amount will they be given? How much compensation will they be given? It depends upon the nature of injury and the percentage of disablement. Right? That exact figures will tell you. Every employee, including those employed through contractor and who suffers injury in any accident arising out of or in the course of his employment, shall be entitled for this compensation under this act. Right? There are two ways of claiming the compensation by the workman. What are they? First is, workman can claim the compensation as per the provisions of Workman Compensation Act, or else he can file a suit in the court claiming compensation. See, they can do any one of these two. Both are not permitted. Right? Workman can choose only any one of the above mentioned options for claiming compensation. He cannot opt for the both. Either he can claim the compensation as per provisions of WCA, or he can file a suit claiming compensation. Right? That is not limited to physical injury, but extends to the reduction in the earning capacity of the workman. Right? It need not be limited to the physical injury only. If at all at the workplace, if the employee gets psychologically disturbed, right, mentally disturbed, so that his earning capacity will become low, then also he has to be compensated. So it need not be totally physical one, even psychological disturbance also matters. Right. Compensation, how the compensation is paid, as I've told you, it can be either directly as per WCA, or they can approach law court. Right. The amount of compensation payable to a workman depends upon the nature of injury, his monthly wages with respect to his completed years of age in that particular company. Such compensation may be for death, disablement, whether total or partial or temporary or permanent, whatever it is. If there is total disablement also, they will be compensated. Temporary disablement also, they will be compensated. Like that. I mean, for death, it will be compensated. As per section 4 of WC Act, the amount of compensation shall be as follows. In case of death, an amount equal to 50% of monthly wages multiplied by the relevant factor, or an amount of rupees 80,000, whichever is more, will be paid. Right? In case of death, it will be paid for their dependents. Right? In case of permanent or total disablement, an amount equal to 60% of monthly wage multiplied by a relevant factor, or an amount of rupees 90,000, whichever is more, is paid to the employee. In case of permanent partial disablement, where it results in from injury, compensation is provided by the percentage loss of earning capacity caused by that injury. Right? Right. So we'll just have a look at a few figures here as far as this Compensation Act, Workman Compensation Act is concerned. According to this act, also identifies occupational diseases, right? If at all we have seen partial disablement, if at all due to the occupational issues in course of their employment, if at all the employee loses his right arm, 70% of the compensation will be given. Loss of one eye, 30%. Loss of thumb, 25%. There will be this much loss of earning capacity. Loss of right arm, 70% of the loss of earning capacity will happen. There is a loss of one eye, 30% of loss of earning capacity. The person loses his thumb, 25% of his earning capacity will be lost. So they will be compensated as per that. Of course, an employer is not liable for compensation when the injury does not result in the disablement for a period exceeding 3 days. The injury results in death or permanent total disability due to the worker was at the time of accident under the influence of alcohol, drink or drugs, then he will not be eligible to claim compensation. the worker willfully disobeys the order given by the superiors, and he'll not follow the safety precautions, then also if he willfully disobeys and willfully wantingly, if he does not follow the safety precautions also, he is not eligible for compensation. The worker, if he willfully removes any safety gadget given to him, though he knows that it is dangerous, if he willfully removes the safety gadgets, then also he is not liable for compensation. Right? That is about Workman Compensation Act. Right? So, Compensation Act, as we have seen, it is applicable for all the employees except the army personnel. It is the main objective of it is to support the employees when there is an accident and which causes either death or disablement, partial or full disablement for the employees. Right? So the amount of compensation depends upon the amount of loss occurred. Right? The loss of earning capacity occurred. If at all the death occurs, then what happens? The amount will be paid to their dependents, right? Either a wife or children, right? The compensation will be paid for, right? Now, we look into what is Industrial Dispute Act, right? The Industrial Dispute Act 1947 extends to the whole of India and regulates Indian labor law so far as that concerns trade unions as well as individual workmen employed in any industry within the territory of Indian mainland. This act is enacted on 11th March 1947 and it came into force from 1st April 1947. Right. So this law basically looks into the disputes which are caused in the industries, and so that it maintains harmony between the employer and the employees. This act also provides for regulation of layoff and retrenchment. The objective of this Industrial Disputes Act is to secure industrial peace and harmony by providing machinery and procedure for investigation and settlement of industrial disputes by negotiations. Negotiations will be carried out between the managers and the sub-staff, between the different levels of managers, so that there is peace and harmony maintained in the industries. Right. Generally, the cause of industrial disputes, what are the various causes of industrial disputes? Generally, it will be a demand for pay and benefits. Employees wanted a hike in the pay and the benefits. Employers are generally, they are not supportive for this, and so there will be a dispute. Demand for hygienic and safer working conditions. Demand for better labor welfare and social security measures like ESI Act and all. Demand for recognition and appreciation, of course. They are not recognized, even then that might be a cause for dispute. Demand for justice for an individual or a group of employees. One-upmanship among the unions. External interferences will also be there, will also be a cause of dispute. Numerous labor legislations. If at all the factory is not following these legislations properly, then also the employees are dissatisfied, they get dissatisfied and they arose disputes, right? So there are a number of causes for industrial disputes. It is basically a difference between the workman and his employer connected arising out of following activities. Generally, we can list them into 4. Dismissal of workman, discharge of workman, retrenchment, termination of workman from his services. These causes industrial disputes. In addition to this, demand for pay, demand for hygiene and safer working conditions, demand for welfare measures, recognition and appreciation, for demand for justice, right? In addition to this, even if a workman is laid off his service suddenly without pre-intimating, then also there might be, it might lead to dispute, right? The objectives of this Industrial Dispute Act is to provide suitable machinery for the just, equitable and peaceful settlement of disputes, to promote measures for securing and preserving amity and good relationship between employers and employees, to prevent illegal strikes and lockouts, to provide relief to workers against layoffs, retrenchments, wrongful dismissal, and victimization, to promote collective bargaining, to ameliorate the conditions of workers, and to avoid unfair labor practices. So to look into all these things, the Industrial Dispute Act is laid. Right. Generally, what are the reasons? Demand for higher wages, as we have just now seen. Demand for payment of bonus, higher social security measures, safer working conditions, improved labor welfare, and other benefits like canteen, restrooms, recreation, accommodation facilities, travel arrangements, and all. So, these are all may lead to disputes in the industries. Right. We'll just have a look at the applicability of this act. The Industrial Dispute Act extends to the whole of India and applies to every industry and its various industrial establishments carrying on any business, trade, manufacture, or distribution of goods and services, irrespective of the number of workmen employed there. Right? Irrespective of number of workmen employed there, this is applicable. IDA is applicable. Every person employed in an establishment for hire or reward, including contract labor, apprentice, and part-time employees, to do any manual, clerical, skilled, unskilled, technical, operational, or supervisory work are covered by this act. Right? Anyone, either he can be a contract laborer or apprentice or a part-time employee, who can be a clerk or skilled or unskilled labor, technical one, operational one, anyone who is working in that organization or a business. For any of this act is applicable. This act, though, does not apply to persons mainly in managerial or administrative capacity. Persons engaged in supervisory capacity and drawing more than 10,000 per month, or executing managerial functions, and persons subjected to Army Act, Air Force and Navy Act, or those in police service or officer or employee of a prison, it does not apply. This does not apply to persons mainly in the managerial capacity, administrative capacity, supervisory capacity and drawing more than 100 per month, right? And also it is not applicable for army people or any defense personnel as such, army, navy, air force, any defense, then this act is not applicable because it is clearly Industrial Dispute Act, right? Right. This act, if at all there is any conflict occurring in any industry, then what will it do? Right? If any grievances, any conflicts occurs, then what happens? What will this, as per this law, what happens is, this Industrial Dispute Act provides elaborate and effective machinery for investigation and amicable settlement of industrial disputes by setting up various authorities. Right? They set up various authorities and they send them for to check the proof. Right? They are works committee, right? Works committee means they are obligatory in factories with more than 100 employees, right? They promote amity and goodwill. Work does, when will this work committee be sent for this? It is when the employees are more than 100, then work committees will be framed and they will be sent to uh, promote goodwill among the employer and the employees. Next is uh, conciliation officer. Conciliation officer. What does he do? He is appointed by the state government to mediate and promote settlement of disputes. Conciliation officer is appointed by state government. What will he do? He will mediate and promote settlement of disputes. Next, have conciliation board, board of conciliation. Right? It is constituted by the government. It has an independent chairman and 2 or 4 members from employers and employees, so that justice will be done on both sides. Right? Conciliation board is constituted by government. It has an independent chairman and 2 or 4 members from employees and employers side, both sides. Next, you have court of inquiry. They are appointed by state government to inquire into the causes of disputes and anticipated disputes. So what is the cause of dispute, or what are the disputes which may arise? Right? They'll just look into that. Next, you have labor courts. Labor courts, what do? They also are appointed by the government. It selects a person from judicial office. Right? He adjudicates matters relating to employment, discharges and dismissals, withdrawals of customary privileges, and facts about the strikes and lockouts. He looks into various things. Right. Next, you have National Tribunal and Industrial Tribunal. The industrial tribunals are appointed by the appropriate government under the provision of this ID Act. Right? It consists of judges of High Court level. They adjudicate on matters pertaining to wages, allowances, hours of work, leave with pay, bonus, PF, provident funds, gratuity, job grading, retrenchment, strikes and lockouts. They look into all the aspects of industry related to employer and the employee. And hence it consists of High Court judges, High Court level judges. Next, we have National Tribunal. It is led by central government. Central government has to appoint a person of the rank of High Court judge and below the age of 65 to adjudicate disputes of national importance. Right? In addition to this, you have arbitrators, grievances and settlement authority to settle down any grievance or any disputes occurring in the industry. Right? Right. That is about Industrial Dispute Act. Right. Before winding up today's session, we'll see what we have seen in today's class. We have seen the salient features of Indian Factory Act, ESI Act. We have seen in detail about Workman Compensation Act and also Industrial Dispute Act. You students must be aware of all these things because future you may go and work in any company or in any organization, or you yourself might set up a factory or a company or any startup or thing. For you, you must understand, be aware of all these acts. Right? Thank you. Thank you for being with me. Meet you in the next class with a few more interesting topics.